Good day, Crime Talk aficionados. This is Scott Reisch from Crime Talk. Thanks for watching and thanks for listening to the podcast. First on the docket, Letecia Stauch found competent to proceed. Maybe the defense challenges the findings. Second, Lori Vallow has court tomorrow. What we should expect. Third, a Miss Maxwell is complaining about her surroundings at the detention center. Fourth, sorry about that, but hey, would you mind coming to our bias training? Fifth, our John Doe case. And finally, our dumb criminal contestant of the day. Let's talk about it. Good day, Crime Talk aficionados. My name is Scott Reisch. This is Crime Talk. Thanks for watching. First on the docket, Letecia Stauch found competent. That's right. For those of you who don't recall, Letecia Stauch, the woman accused allegedly of being involved in the death of 10-year-old Gannon Stauch, underwent a competency evaluation at the request of her defense counsel. So Ms. Stauch went off to the city of Pueblo, where the mental health facility is located, and the evaluation took place. Well, that report was returned, finding Ms. Stauch competent to proceed and stand trial. Now, pursuant to statute, the defense, and frankly, either party could have objected. Say, for example, if the result had come back that she was not competent to proceed, the prosecutor could ask for a second evaluation. Well, in this particular situation, the evaluation said that she's competent to proceed, and therefore the defense is asking for a second evaluation. And pursuant to the statute, specifically Colorado Revised Statute, Section 16-8.5-103, Paragraph 2, if either party objects to the court's preliminary findings, or if the court determines that it has insufficient information to make a preliminary finding, the court shall order that the defendant be evaluated for competency by the department and that the department prepare a court-ordered report. The statute further states, within 14 days after receipt of the court-ordered report, either party may request a hearing or a second evaluation. If a party requests a second evaluation, any pending request for a hearing shall be continued until the receipt of the second evaluated report. The report of the expert conducting the second evaluation shall be completed and filed with the court within 63 days after the court order allowing the second evaluation, unless that time period is extended by the court for good cause. Good cause can be basically, hey, we're really busy down here in Pueblo. We're going to need a little more time. So once the second evaluation is prepared, it obviously depends on what the result may be. If a new evaluation states that Ms. Stauch is not competent to proceed, guess what? Then we're going to have a hearing, and that hearing would have to be held within 35 days. Now, even if there was a finding of competency the second time around, the defense could still request a hearing to address the issue of competency for appellate purposes. Normally, if the second evaluation comes back as competent, the party challenging the reports will usually concede that there is not a basis for that. Now, the public defender's office, who's representing Ms. Stauch, may actually have their own evaluation done by somebody that they think is competent and will testify that she is not competent to proceed. This could take many, many more months for this case to really get going. As you may recall, we were still set for a preliminary hearing and a proof evident presumption great, which is a hearing that's usually combined in a case where, such as Ms. Stauch is charged with first-degree murder after deliberation, and that proof evident presumption great is a hearing to assure both the court, the defendant, and the people that if the evidence is overwhelming against Ms. Stauch, that she should be held without bond. The court could say there's sufficient evidence, but it's not so great that she wouldn't be a flight risk and set the bond, but the court would more than likely set the bond so high that Ms. Stauch would be unable to make the bond. We'll see how things shake out on this particular case. It will not be done anytime soon. I wouldn't expect any real movement on this case until close to the end of the year or early next year. Next on the docket, Lori Vallow has court tomorrow. What should we expect? Possibly more delays. As you may recall, the prosecutor in both the case for Lori Vallow and her husband, Chad Daybell, a motion has been filed for joinder. And one of the reasons cited in the motion for joinder is that, hey, these cases got sent to separate judges because that's what happens. When a case comes in, they're literally randomly selected, usually by the number at the end. Some have literally random processes to decide which judge will receive a case and will be handling that. So in this particular case, Lori Vallow, the district court judge is Dane Watkins. And in Chad Daybell's case, it's Judge Boyce. Judge Boyce has already set Chad Daybell's case for trial, so the matter is clearly ahead of Lori Vallow's as well. So what could possibly take place? Well, Judge Watkins could say, until these motions are ruled upon, we'll just go ahead and enter a plea of not guilty and let's set the matter for trial, and we'll just act as though these are going to be separate cases throughout. The court could say, I've read the motion, I've conferred with Judge Boyce, and there may be procedures in place internally for the judges to decide who would take the case. So that would mean that the case could be sent over to Judge Boyce, or the other case could be sent over to Judge Watkins. Sometimes the senior case is the kind of the controlling one. It'll follow. It just depends on each jurisdiction, and I'm not exactly sure what the procedure will be. But hopefully there won't be a significant delay in this matter, and that at the arraignment, a plea of not guilty will be entered, and we'll sort out the motion for joinder issues later. Now, it does make sense for this to take place sooner rather than later for scheduling purposes, because everything can be on one track. If we proceed down two separate tracks and then we got to jump over to the other track, guess what that means? Delays. It means continuances, because somebody on the other opposite track is going to say, ooh, that date doesn't work for me. Regardless, hopefully the court will say one of these two judges is going to take the case right now, and let's keep these cases rolling. Next on the docket, let's talk about Miss Maxwell. Now, we're going to refer to Miss Maxwell as simply Miss Maxwell, and her former boyfriend simply as a guy named Jeff. Why, you may ask? Because the YouTube demonetization algorithms seem to get triggered based upon Jeff's last name. So let's talk about Miss Maxwell. As of today, Miss Maxwell has been in the Metropolitan Detention Center in Brooklyn, New York for 69 days. She's currently awaiting trial on all counts and completely maintains her innocence. Now, Miss Maxwell has some complaints. First of all, she's complaining that she was in solitary confinement where she was monitored 24/7, and she was in that cell 23 hours a day, out only for 1 hour a day for exercise. The detention center said, hey, we're not going to put you in general population given the high-profile nature of your case. And, oh yeah, by the way, there's this whole COVID thing, so we're trying not to spread the virus around much anymore, and so therefore it's nothing personal against you. Miss Maxwell also complained that she was put on suicide watch. This required her then to be checked every 4 hours, and the only garments she was allowed to wear were paper clothes that would break under her weight if she attempted to harm herself. Miss Maxwell is also complaining about her complete lack of privacy. I hate to break it to you, but when you go into custody, you have no expectation of privacy whatsoever. Now, Miss Maxwell has complained that she's been subjected to random searches by detention center personnel, and that this lack of privacy is standing in her way of her researching and assisting her attorneys in her defense. Now, every criminal defendant has a Sixth Amendment right to participate in their own defense, which usually means meeting with their attorney, reviewing the discovery, and preparing for trial with the defense attorney. However, reasonable accommodations can, in fact, be made. The detention center said, Miss Maxwell has actually been given 13 hours a day to work on her case. So no violation there. Additionally, Miss Maxwell is saying that she is deliberately being mistreated and states that she was treated worse than other similarly situated pretrial detainees. The court heard all of these arguments made by Miss Maxwell through her attorneys and denied the claims. Now, certainly trying to prepare for a trial while you're in custody is not ideal conditions. However, it's just a reality of life. Certainly, as a defense attorney, I understand that Miss Maxwell wants to participate in her defense, and there are probably tens of thousands of documents and videos that she needs to review. Now, some would say, what does she need to review it for? Because, hey, she was there. But her attorneys are obviously zealously advocating for her so that she can feel as though she is participating in the process. My general advice would be you got to make do with the situation that you are given and maybe spend less time worrying about the conditions that you're working under. Do the work and focus on trial preparation. And from what we can see, it looks like this case is going to go to trial. And frankly, I can't wait. Let's take a quick recess before we continue with the docket. Please, I urge you, go to CrimeTalkSearch.com and sign up for your background subscription. This will be the best thing that you have purchased in your life. If you go there, you sign up, you can enter a name, you can search as many names as you want, and the beautiful thing is you get to do it anonymously. And when you search that individual's name, guess what you get? You get a report. And in that report, which is a result of literally millions of public records being searched and organized all for you, for that particular person that you searched, you will get a report that will identify emails, phone numbers, and social media identified with that person that you are searching. More importantly, you get criminal background records. You get personal property records. You get divorce and marital records. Think about how important that could be in today's era where people date by swiping to the left or swiping to the right or something along those lines. How do you know who the person is on the other side? You don't. So check them out. Go to CrimeTalkSearch.com. You'll be absolutely satisfied that you did. Next on the docket. Hey, sorry about all that. Would you mind coming to our bias training? Yep. Take a listen to this story. Florida deputies detained an innocent black man who says that he fit the description of an accused burglar. Body cam footage showed the man and the officers chatting about the sensitive nature of race relations, and the encounters left such an impression on the county sheriff that he arranged to have the man assist his department with its implicit bias training. No one would want to be pulled over or arrested, basically, while an investigatory stop is done. But that's what happened to Joseph Griffin. He was out jogging last month in a town about 30 miles north of Orlando when deputies pulled up in a squad car. When the officers pulled up to Mr. Griffin, they actually apologized and said that they have to detain him while they checked the surveillance photos of the suspect to make sure that it, in fact, wasn't him. Now, Mr. Griffin had been live streaming the encounter on his phone, and one of the officers volunteered to hold his phone to continue the stream while Griffin was placed in handcuffs. Frankly, I think the officers did a great job in this particular scenario. There is no turn off the camera. We're not going to do that. The police officers said, we get it. Let's make sure everything's on the up and up. So while waiting for the information of the suspect to come in, the body cam video showed Griffin and the deputies talking about the situation. 7 police cars arrived, and he stated, hey, listen, man, I was out just jogging And next thing you know, I'm put in handcuffs. The police were somewhat apologetic and said, but we don't know that for sure who you are. You got to see it through our eyes, says one of the deputies, who appears to be black himself. A little while later, the deputies tell Mr. Griffin, we appreciate you being very cooperative. Other people would just, go off. And I'm not trying to get shot over this, is what Mr. Griffin replies with a nervous laugh. Obviously has a little reason to be scared, not necessarily of these officers, but just how sometimes these situations escalate. So the sheriff saw how his deputies handled this particular situation and believes that the officers actually did the right thing. The sheriff posted the video to social media, and some people were very upset, saying it was racial profiling. But the reality of it is the cops were doing their jobs by saying they had a suspect. They were polite. They were professional. Nobody wants to do it, but the police were justified based upon the information that they had. Once they checked the situation and determined Mr. Griffin wasn't involved in the burglary, he was released with the apologies of the police officers. Police chief actually issued a statement saying, we detained a guy who was out jogging, but who unfortunately fit the initial suspect description. The sheriff went on to say, I just want to say how proud I am of the deputies who handled this call. Granted, nothing like Facebook Live existed when I started out, but I don't know if a young Mike Chitwood, that's the sheriff, would have kept a live video running for somebody I was detaining. These guys did it because in the moment, they understood what it meant to Mr. Griffin, who was going out of his way to be cooperative and respectful. Everyone involved in this deserves recognition for a job well done. The sheriff goes on to say that Mr. Griffin is going to come out and join us during implicit bias training and tell this story from his perspective. The chief goes on in his statement and says, I think we can all learn from this point of view, just like he has listened to ours. Mr. Griffin is a military veteran and a medical professional, and the sheriff told him we'd train and hire him as a deputy in a second if he ever wants a new job. After this encounter with Mr. Griffin, the deputies were actually able to identify and arrest the suspect that they were in fact looking for. This is a situation, obviously it's unfortunate for Mr. Griffin. However, the police did it right. As you can see, they treat Mr. Griffin with dignity and respect, and I love the fact that they didn't get upset about him videoing and live streaming the entire encounter. That shows professionalism on the part of the police department and doing what they're supposed to do, which is to serve and protect the citizens. Nice job for everyone involved. And I think Mr. Griffin also deserves huge accolades for doing what he can to make sure that others will understand how he feels in this particular situation. Kudos to everybody. This is the type of situation where the police were doing their jobs. They did it professionally. They treated Mr. Griffin with dignity and respect. They could have made a big deal about his phone, but they actually said, we get it. Let's make sure we're doing everything right for the world to see. Shows a lot of professionalism on the part of the police. And Mr. Griffin, my hat's off to you because you kept calm, cool, and collected in this entire situation, and it didn't have to go into something bad. That's great. Everyone treated all with dignity and respect, and the matter was sorted out appropriately. Nice job to everyone involved. Next on the docket, we have a cold case of a John Doe that was found in Hamilton, Ohio in 1997. May 18th, 1997 to be specific. On that day back in May, a decomposing body of a white male was discovered at the Great Miami River near the Rygart Road on the south end of the Horseshoe Dam in Fairfield Township by Indian Springs, north of Hamilton, Ohio. The police suspect that the man may have been the victim of a hit and run. They believe that the deceased man was between the ages of 35 and 60 years of age, roughly 5 feet 10 inches tall, and weighing between 120 to 140 pounds with a husky build and an unusual protruding chin. An autopsy discovered surgical scars in his facial bones, indicating he probably would have had a scar on the inside edge of his right eye. Investigators also believe that within a year, his teeth had been removed or extracted. He also had cirrhosis of the liver, so more than likely had a problem with alcoholism. If anyone has any information about this particular case, and somewhere someone knows who this individual may be, the driver has nothing to worry about. Since the case was back in 1997, any statute of limitations would have run. If you have any information, please contact the Butler County Coroner's Office and ask for William Havens, the investigator there, at 513-785-5860. This John Doe needs to be identified, not only for him, but for his family. And I think it's always sad when we do these cold cases, particularly as it relates to the John Doe matters, where literally no one even is looking for these individuals. It's kind of sad, so maybe we can at least identify who they are and have a proper name put on a headstone. Next on the docket, our dumb criminal contestant of the day. Now, do you remember as a child walking through the stores, your parents said, don't touch, keep your hands off things. First, you don't want to break it. And second, you don't know where they've been. Well, this is probably the example your parents were thinking about. Take a listen to what allegedly happened with Teresa Stanley. Apparently, she had gone into the Lion's Den adult superstore and was apparently looking at some of the toys. Well, it is then alleged that workers saw Miss Stanley remove a toy from its packaging and was now fully nude in the store, whereupon she began using the toy. When the police arrived, Miss Stanley immediately dropped the toy to the ground. She was arrested for theft and indecent exposures. Both are misdemeanors, but the indecent exposure could carry possibly having to register as a sex offender. Miss Stanley is currently being held in the St. Lucie County Jail on a $1,500 bond. Some of her previous convictions include soliciting prostitution and possession of drug paraphernalia. She was also charged earlier this year with grand theft auto and has that case currently pending as well. Needless to say, it would seem as though Miss Stanley is going through a very difficult time, probably involving drugs and alcohol, to make you think that she would be pleasuring herself with a toy in a store while people are watching. That's all we have for you today on Crime Talk. Thanks for watching. We know you have lots of choices out there, and we appreciate the fact that you took the time to watch us. Thank you. Have a great day.